Well, hello, welcome to the November 2023 edition of Outline, DLA Piper's regular planning law series. Today we're looking at the pros and cons of a planning appeal, a controversial topic. And I'm joined today by my colleague, Senior Associate in the planning team, Pieter Claussen. So morning, Peter.
Morning, Trevor.
And appeals are a bit of a favourite of yours, aren't they? You do enjoy a good planning appeal.
Absolutely, yep.
So in the usual way, please, if you have questions and you're watching the live broadcast, please do use the Q&A function at the bottom, and we will try to get through as many questions as possible. We'll have a hard stop on the hour, and we'll do our best to keep it to between 45 minutes and an hour's discussion. Without further ado, let's crack on then. So, Peter, perhaps before we start, there's actually not a law in today's talk. I don't think a lot of it is much more about tactics and strategy, but it is a planning law seminar. So let's start with the law and just talk us through the basis of a planning appeal under the 1990 Act, which is Section 78, isn't it?
Yeah, thanks, Trevor. So as you said, Section 78 provides the legal framework under which an appeal can be made. In a nutshell, an appeal can be made under two scenarios. The first of which is an appeal against a refusal by the local planning authority, and the second is an appeal against the local planning authority's failure to issue a decision on an application within the relevant timescales. Now, appeals are made to the Secretary of State, and in the majority of cases are determined by a planning inspector appointed on behalf of the Secretary of State, unless, of course, the appeal is recovered by the Secretary of State himself. In terms of the relevant periods for non-determination appeals, they are set out in the Development Management Procedure Order. And just to highlight a couple, so a standard application needs to be determined within 8 weeks, an application for major development within 13 weeks, and development where an environmental impact assessment is required is 16 weeks. And I just wanted to touch on non-determination periods, and in particular agreeing extensions of time with the local planning authority. And I think a real practical point to take away is just to be on the safe side. Extensions of determination periods need to be agreed in writing. We obviously had the Gluck case in the Court of Appeal back in 2020, where the court found that a verbal agreement, which was then followed up in writing with the local planning authority, and where the local planning authority had actually only said, "Thank you for your email," the court found that was sufficient to extend the time. But the judges were sort of in disagreement as to where you would draw the line in terms of extending that period for the application to be determined. So for us, it's always make sure that both parties have agreed without doubt to the extension of time for that determination period, because that's what sets the timescale in which you can appeal running, which in most cases is 6 months from either the date the decision is made or the date that the decision should have been made.
It's a really important point, isn't it? And I think we've talked about Gluck on a previous outline, presumably back in 2020, when the case was there. But I think that need to extend the determination period in order to keep that non-determination right of appeal alive is really important, because otherwise, if you get beyond 6 months from either the statutory determination point or the agreed determination point, and you haven't appealed, then effectively you're in the local authority's hands, because unless they refuse, you're out of time to appeal. So you sort of get stuck and potentially have to go back to the beginning of the process. So I think that's quite important.
Yeah, absolutely. And I think the other thing is so just to be mindful, if you've got something like a listed building consent application running alongside that isn't contentious, just make sure you're extending the timelines for both, because otherwise you might be reliant on you might not be able to appeal your listed building consent at the same time, because you might have lost the determination period for that. So it's just one of those points to be mindful of, I suspect.
It's a really good point. And you mentioned at the beginning there are effectively 3 statutory time periods. And it's probably worth saying the 8-week one almost will never apply for our audience. Most of what our client base and our audience are doing is major development, because actually major development, the thresholds are quite low, aren't they? So it's usually that 12-week or the 16-week if there's an environmental impact assessment involved.
Yeah, just touching on major development. If it's a residential development, it's 10 or more dwellings. So as you say, it is really low, or sites of half a hectare. Or actually, if it's sort of commercial development, it's sites on a hectare or more, or where 1,000 square meters of floor space are created. So again, it's major development in most cases.
And funnily enough, the statutory period, really its relevance is to the appeal timetable, isn't it? Quite often, particularly those who are new, developers coming in from overseas who are experiencing the UK planning system for the first time, they look at the statutory determination period and think, right, that's how long it's going to take. Anyone who's ever submitted a planning application knows that is not how long it's going to take. Even for fairly straightforward stuff, you would normally expect it to take longer. The relevance of that period is it triggers the right to a non-determination appeal. That's, to my mind, really is any useful role in the process. Don't assume that your application is going to be determined in 12 weeks, for example.
Yeah, I agree, and I think there's actually something to be said about lodging a premature appeal on a non-determination basis, because actually you can usefully use extensions of time to get agreement on certain aspects, or you know, for consultees to come back and actually, if you know if you're likely to go to an appeal, that can actually be tactically more beneficial, because actually you can iron out things that are in agreement and just leave those things for later that are in dispute.
Yeah. Now, you started by telling us there were two circumstances in which you can appeal, which of course is not quite true, is it? There is a third circumstance in which you can appeal, although query why anybody would ever do it, but we're probably just for completeness. And as a warning, given that we have seen dumb and spectacularly backfire, what's the third circumstance in which you can appeal? A non-determination and...
well, you can appeal against a grant of planning permission, which is subject to conditions. But as you say, that is something that we would never advise someone to do, because Section 79 of the Town and Country Planning Act sets out the basis on which an inspector can determine an appeal, and they can either allow or dismiss the appeal, but they can also reverse or vary any part of the decision the local planning authority's made, whether the appeal relates to it or not. So if you have a grant subject to a condition that perhaps you don't like, we would always recommend that you put a Section 73 in, just to try and get rid of that condition. And if again the planning authority don't accept that, then you appeal the Section 73, having secured the principle of development on your original consent.
And it rarely happens, but it's just worth pausing on it for a minute, because we did see an example a couple of years ago, didn't we, where a planning consultant had submitted an appeal in precisely that circumstance. So planning permission had been granted, but subject to a condition that the client didn't like. What the planning consultant had done is appeal the grant of planning subject to the condition, and had misunderstood what the appeal was going to be dealing with, and so was effectively all of the evidence was about whether the condition was justified or not. And we got involved for various reasons we don't need to go into, but when we got involved, we ended up having to pull the plug on that appeal pretty quickly, because actually what the council did was come after the principle of development and say, actually, forget the condition, we don't think this development is acceptable in planning terms. And so the risk was that actually the appeal might have resulted in a refusal. And at that point, it's not a refusal to amend the condition, it is a refusal of planning permission. You end up with less than you started with. So I completely agree with you. I can't think of a circumstance in which that would be sensible, rather than banking that permission, which at least establishes the principle of development, then submitting a Section 73 to try and amend the condition. And if that's refused, appealing the Section 73, because then you always have your original permission and your principle of development, at least, albeit subject to conditions that you might find unpalatable.
Yeah, absolutely, and I think that's the case anyway. But in the scenario you were just describing, Trevor, it was actually a particularly controversial development, where the lines were slightly blurred as to whether it should have been granted in the first place or not. So, as the inspector has the opportunity to reopen everything, and that was there was a particular nervousness in that case.
I think that's right. And I suppose timing. So we've talked about the sort of statutory periods and when your right to appeal arises, and that 6-month period. But I think that there's a sort of practical point that needs to be thought about, because I've lost count of the number of times that I I've talked to a client about whether we should appeal quite early on in the process, sort of, at the end of the statutory period, or maybe at the end of the first extension of time. And there's quite often a reluctance to appeal because obviously there are downsides to appealing, and therefore the prospect of getting a negotiated consent is always quite compelling. But then that process can take a long time, particularly if the 106 isn't being negotiated until after the resolution to grant. And suddenly you find yourself 3 or 4 years down the line, still frustratingly stuck trying to secure that planning permission. And at that point, everybody has a habit of looking back and saying, I wish we'd appealed at the first opportunity, because actually we'd have been through the process by now and we'd be on site. And I think there's something in that, in terms of sometimes recognizing that if this is going to be a painful process for the planning authority, an appeal might actually, counterintuitively, be the quicker route to getting what you want. So I think that, for me, is one of the potential benefits of an appeal, but only if you do it early in the process. What you don't want to do is spend 3 years negotiating it, then give up, and then spend time in the appeal process.
Yeah, absolutely. I completely agree. But it's particularly the point that you said on the Section 106, because they can take time, and actually where there is no timescale in place as you get with an appeal, you often find yourself at the bottom of a long list of Section 106 agreements that the planning authority is negotiating elsewhere. So there is inevitably delay associated with that, and we've seen certainly negotiations go on well over a year, haven't we, Trevor, with Section 106s outside the context of an appeal?
Yeah, absolutely right. So that probably neatly takes us on to sort of perhaps looking at what the benefits and the downsides of an appeal might be. So let's start with the benefits. I don't know about you, Peter. I think one for me is actually on the 106 we were just talking about. I think we all know we have Regulation 122 of the Community Infrastructure Levy regs, which sets out the tests. Effectively, it legislates for the policy tests that are in the MPPF around what a planning obligation has to be, in terms of being reasonable in scale and all the rest of it. And we all know that we regularly have clients who sign up to development, to planning obligations that don't meet those tests, but they do it in order to try and effectively buy their permission, get the local authority to get to the point where they're prepared to issue a permission. So I think one of the benefits for me of an appeal is when you're at appeal, the framework for considering the 106 is completely different. The inspector will require the local authority to demonstrate that the obligations meet Reg 122. And so there's an opportunity, it seems to me, on appeal to actually remove some sometimes quite chunky contributions and on-site obligations that might exist within the 106 that you would have to sign up to if you're going to get the local authority to grant. But actually they will struggle to justify to an inspector under the legal and the policy tests. So that always feels to me like one of the benefits of an appeal that isn't always perhaps front of people's mind when they're thinking about.
Yeah, definitely, and I think that's a nice segue into what I would say is a benefit, which is getting more sensible conditions out of a planning appeal as well, which obviously needs to meet the 6 tests in the MPPF. But how often do we see, in the context of a negotiation for a Section 106 agreement, planning authorities sticking what should either be conditions into a Section 106 agreement, or worse, putting them in both the planning permission and the Section 106 agreement? And the MPPF is clear that if you can have a condition, then you should use it. It shouldn't be in the planning obligation. So that for me is a really nice thing that you get out of an appeal, because you actually get some sensible conditions, and you get them removed, what should be conditions removed from the Section 106 agreement.
Yeah. Any other benefits for you of an appeal?
Well, yeah, I think so. The inspector obviously comes at the appeal from a different perspective. When you're negotiating with the planning authority, it's often there's often a greater weight, I would say, on local politics, whereas the inspector is tend to not be interested in that, and actually they come from a more national policy slant, and that's particularly the case if there is national policy that affects the particular development that's being applied for. So whereas the inspector might be more willing to apply national policy rather than local policy, which can be really helpful when the local planning authority is sort of rigidly sticking to what their local policy says.
I think that is probably the major benefit for me, is those 2 points combined. It is that you're diluting the role that local political pressure plays in the process, particularly if it's a controversial application. Inevitably an inspector will be, it's not to say they won't place weight on what members of the public think, but those members of the public aren't voting at the next election to decide whether the inspector keeps his job or not, in the same way as they are with the planning committee. So there will be a planning weight given to those objections, but not that slightly intangible political weight that inevitably, it's not a criticism of politicians, they're there to represent those who elect them, and so they can be more susceptible to that political objection than is normally the case. But also, again, as you say, that policy difference, a local authority might feel more inclined to defend its development plan. They might be more resistant to the suggestion that the plan is out of date, or that there are material considerations that outweigh it. Whereas an inspector, ultimately, let's not forget, a planning inspector is exercising a decision-making function on behalf of the Secretary of State. They're doing it in the name of the Secretary of State. So you might expect your average inspector to place more weight on the Secretary of State's policies than a local authority who may not agree with the Secretary of State's policies. So I think that can be there. And to an extent, I think for me, it's a tough one to call, because it sort of depends on the political zeitgeist of the time, doesn't it? And if you think that 2012 is probably a good example. We had the first National Planning Policy Framework. We had paragraph 49 and the whole 5-year land supply out of date presumption in favour of sustainable development process for housing. And you saw huge numbers of residential consents being approved by the Secretary of State, having been refused by the local authority. And you saw a real route through to housing delivery by appeal. But that ebbs and flows. We've had a large number of Secretaries of State since 2012, and each one has had a slightly different view on housing. And so you sort of see that ebb and flow of whether putting a decision in front of the Secretary of State or in one of his inspectors is going to help you or not. So you sort of have to judge the political mood music at the time, I think, to try and work out how that's going to go. And you can get some idea of that from looking at recent cases and seeing whether there's a trend towards approval of a particular type of development or a trend against, and sort of feel your way into whether an appeal is therefore tactically sensible.
Yeah, I completely agree. And actually, it's one to bear in mind at the outset of the application, isn't it? Probably before you even go into pre-app discussions as to whether this is politically likely to end up in an appeal scenario. Because then you probably want to be looking at how helpful the national policy is to your application as well as local policy. Yeah.
What about the downsides? I think one of the big downsides is cost. An appeal, we'll talk about different procedures in a moment, but if you're at a full planning inquiry, it's not a cheap process, as anyone that's been through it will know. So I think the cost has to be factored in. I suppose, though, particularly if you're appealing early enough, actually the time that you save, you're on site quicker. So there's holding costs for the site, the other sort of less direct costs of the planning process need to be factored in, but there's no getting away from it. A planning appeal can be a costly process, can't it? So that's certainly for me a big downside.
Absolutely. And I suppose it depends on the amount of experts that you're going to need as well in terms of how big that cost is going to be, doesn't it? I think another one for me, Trevor, is the delay that you can sometimes experience with appeals. And that's particularly the case, I think, certainly going through the pandemic and coming out of it. There is an enormous backlog of planning appeals still in the system, and there is a delay to the process. I think it's fair to say that the planning inspectorate's catching up, but it's not quite there yet to meet its aspirational targets that I think it sets out in its own guidance. But there is that aspect of delay. But of course, that's subject earlier to the point that you made about sort of the delay that you can experience with local planning authorities anyway.
I think that's right. And actually, weirdly, at the moment, inquiries seem to be being determined quicker than perhaps hearings and written reps. We'll perhaps come back to that, but oddly, an inquiry seems to be getting to a decision much quicker. But you know, you can be looking at 12, 18 months. You can. That's probably a worst case scenario at the moment, but it's not impossible. So it kind of comes back to the point I was making earlier. You sort of have to make the decision to appeal early enough. If you do, then 12 to 18 months is actually not a bad timeline versus a planning application. But if you've already spent a couple of years or more negotiating the planning application, that extra delay can be really unpalatable. So it's certainly one of those downsides that needs to be factored in.
Yeah, absolutely.
We've had a question come through before we move on to actually sort of talking about the nuts and bolts of an appeal. We had a question come through which goes back to the discussion we were having at the beginning in terms of, and actually that we've just touched on again with delay, that point about the time at which you appeal. And the question is here, what about the fact that there's a policy requirement that local authorities approach planning in a positive way, and that you look to try and negotiate and find a solution to a planning application rather than resorting to an appeal. I suppose I think that policy is very much aimed at local planning authorities. I don't know about you, Peter, but I don't see that policy in any way affects when an applicant decides to appeal. And I've certainly never seen an applicant be criticised for appealing too soon. Ultimately, you have a statutory right to appeal.
Yeah, exactly. Yeah.
For me, that policy is more about a local authority not rushing to a refusal when actually they could have, if they'd taken more time, resolved some of those issues if they'd worked with the applicant. So I think my answer to the question is I don't see that there's any policy or other impediment that could result in an appellant being criticised on appeal for having appealed too soon.
No, I agree, and I think it would take a brave inspector to sort of say that you shouldn't have complied with the statute. The statute sets out when you're allowed to submit an appeal. So I agree with you, Trevor.
Good. Always good when we agree. So let's come on to actually the submission of the appeal itself. We've talked about there are three processes: written reps, hearing, and inquiry. I think probably most people are familiar with them, but is it just worth looking at what the pros and cons are of each, Peter? Should we start with written reps? What's your thoughts on that?
Yeah, I suppose written reps is obviously it should be the most straightforward and quickest to determine, because everything is done on the paper. And I think there is a real benefit to written reps if the extent of issues at play are relatively narrow between sort of the points of disagreement between local authorities and the appellant. So written reps can actually be a really useful way if the issues are relatively simple and minor, to get through into the system and through it, subject to the delay point we were talking about earlier, but relatively quickly. For me, that is the only time that I would sort of recommend a written reps appeal. Anything with complexity that you sort of need an expert witness at, I would suggest that written reps is potentially not suitable.
I agree. I think it can be really effective, and so I've seen it in a context where the only thing in dispute is the form of the 106, for example. Actually, there's a kind of yes or no answer almost, isn't there? And you can get that quite quickly. I think one of the downsides for me, particularly if you've had an officer recommendation to approve, but the committee has voted to refuse the application, the local authority sort of gets let off the hook a bit, because the officers, the professional experts within the council, are able to work on the drafting of those written submissions and to make them robust. Whereas if it was an inquiry, say, those officers who were in favour of the scheme and were recommending approval are not able to turn up and defend the council's position, because their own expert professional conduct rules would prevent them from that. They've got to give their own professional view to the inquiry, but they are able to be involved with the production of written reps. So you can sometimes find in that situation that actually written reps allows the council off the hook, alongside the fact that actually you don't get to cross-examine their case. You get a right of reply as an appellant to highlight what's wrong. But certainly, I mean, we've seen cases before where local authorities have said some pretty outrageous things in their written statement, and you just don't get the opportunity to properly, in front of an inspector, explore just how ridiculous that position might be. So I think that's the big downside for me of written reps.
Yeah, I agree. Just moving on to hearings, I think that it's sort of the hybrid between the two, isn't it? And they're probably the most difficult tactically to prepare for. I don't know what you think, Trevor.
They're my least
Yeah,
favourite of all the appeal routes, because you don't have, at least with written reps, you get the ability to craft your argument in the way you want it, and you get the ability to say what you want to say in response to what the other side has said. With a hearing, yes, you have that exchange of statements case, but ultimately, on the day, you're in the hands of the inspector as to what questions the inspector asks and what follow-up you're allowed to make. And so I have to say, I tend to find it quite an unsatisfactory process, where I think you get quite a confused situation by the end of the hearing
yeah.
quite often, and it can be really quite difficult to predict the result. So my instinct is always to look at an inquiry or a written reps and try to avoid a hearing at all costs, because I just don't think it's a particularly effective process.
I agree, and I think it's the ability or the inability of the parties to be able to cross-examine each other's cases. You're, as you say, you're entirely at the hands in the hands of the inspector as to whether you're actually allowed to prod the evidence and test it even further, or whether the inspector just takes the point and moves on. So it's they are difficult tactically to prepare for, and as you say, you just don't know what's going to come up particularly, or how it's going to be managed.
And then there's the inquiry, and I think we probably need to say little about that. The benefit of an inquiry is you get to properly test the evidence for each party's case, and so that ultimately it's the most thorough examination of the issues that you can have. Downside is it's the most expensive because it takes longer, and all the rest of it in terms of the hearing itself can be longer, albeit the process at the moment really isn't. But that for me, it's the best possible route, in terms of you have complete control over how you present your case. You also have largely complete control over how you challenge and attack and highlight the weaknesses in the other party's case. So it's the most effective, and whenever you look at the stats that PINs produce, there is a much greater likelihood of a successful appeal through an inquiry versus the other two methods. And I think the reason for that is because you do get to properly test and examine the case of the local authority. There's nowhere for them to hide. If their reasons for refusal were rubbish, that will be exposed through proper cross-examination and a proper examination of the evidence in general.
Yeah, absolutely. It's by far and away our preferred means of an appeal, isn't it? The inquiry, because you can sort of, everyone is prepared for it. Everyone knows the case, and it is just the neatest way of the inspector being able to see how robust each party's case is, because there is that opportunity to cross-examine and test evidence.
You can see the inspector, which in a written reps you can't. So you can see, you can try and read the inspector, what points are landing with the inspector, what points aren't. Where is it that the inspector might not quite have followed the point, and we need to go back and find another way of making it. Whereas with written reps, you're just relying on the inspector to get it in the way that you wrote it and to understand what you were trying to get across. You haven't got that ability to kind of flex in the way that you do. Likewise with witnesses, you sort of, if you're cross-examining with a witness, if you can feel your way into when you've got a witness on a run, or you can feel your way into when you need to back off because actually witness isn't going to give, and you're just going to harm the case by keeping going. So that actually being in the room, being able to read the players in the room, I think is part of why it's a more effective process. But of course, we don't get right to choose anymore. Used to, but we don't anymore. Ultimately, it's in the planning inspectorate's gift as to which process. So I don't think we need to go into it today. I'm conscious of time, but if you're looking for an inquiry, I sort of always work on the assumption the inspectorate is trying to push things down to written reps or hearing if possible. So you do need to make sure that you're looking at the published criteria and making sure that you're presenting a compelling case as to why it should be an inquiry. Particularly, as in my experience, quite often, whilst an appellant is pushing for an inquiry, a local authority will be pushing for something else. They'll be pushing for written reps or a hearing because they don't want necessarily to have to go through that inquiry process. So I think it's important, if you are, that you're setting up your case in the right way to try and persuade the inspectorate that an inquiry is necessary.
Yeah, absolutely. And I think on the flip side of that coin, though, I don't think you can ever assume you're going to get an inquiry. And so, every time you're preparing for an appeal, it's got to be robust, and it's got to be robust up front, and it's got to go in with the evidence that you need, sort of with the sort of almost sort of envisaging the worst case scenario that you do end up with written reps, and that this is going to be all that the appeal is determined on.
I think it's a really good point. In theory, the inspector has a discretion to allow you to produce more evidence in written reps or hearing, but you don't have a right to. And so you've got to make sure, and that probably leads us in now to a discussion about statement of case, doesn't it? And statement of common ground, but you don't have that right to produce more evidence, so it is important. Before we do the statement of case, though, let's just do the statement of common ground, because there are two sort of substantive documents that have to be submitted when you appeal. One is the statement of case, but the other, which I think sometimes gets overlooked, is there is now a requirement on the appellant to submit a draft statement of common ground with the appeal. Now, I think it gets overlooked because actually I think tactically there can be a real benefit to getting a good draft of the statement of common ground in. And I say that for two reasons. I think firstly, it's meant to be in a document that is agreed, but as appellant, you get to write the first draft and put it in front of the inspector without having tried to agree with the local authority. So you get to sort of set the tone for what you think ought to be capable of agreement. And that can, I think, sort of be quite nice in terms of positioning, especially because of my second reason for thinking that it shouldn't be overlooked, which is that typically a local authority will be reluctant to negotiate and try to progress the statement of common ground until quite late. I mean, sometimes you're still negotiating it on the day the inquiry opens, by which point, of course, the document is pointless, because the point of the statement of common ground is to agree the matters on which you don't need to call evidence. And if you're doing that after you've exchanged proofs of evidence, you've already incurred the cost, so it kind of becomes slightly pointless at the end. But because it takes all that time sometimes for a local authority to engage with that process, it means that you are continuing to set the tone as to what ought to be capable of agreement, and that can be useful, I think, tactically, in terms of what the inspector's reading before the inquiry, because they've only got that version, sometimes not any other version, because no progress has been made. But also it can be helpful in terms of costs, and we'll perhaps come back to costs at the end if there's time. But actually, if you have said from the very beginning, we ought to be able to agree these things, and the local authority has refused or just hasn't engaged, you then call evidence, you have to go to the cost of drafting proofs of evidence on those points, only for them to then subsequently sign a statement of common ground that says, yes, we agree you don't need that evidence.
Yeah.
Then you're starting to get into the territory of unreasonable behaviour from the local authority, and potentially a partial reward of costs for you having been put to the cost of preparing evidence that ultimately you didn't need because it wasn't a matter that in the end was in dispute. So I think it's worth putting the time into that and going for quite a comprehensive statement of common ground at that point as a draft document to submit.
Yeah, I completely agree, and actually it can be really helpful where the local authority do engage with it, because it obviously sets the platform for the basis of the appeal, and you can almost sort of start to tactically work out where the direction the appeal is going to move in, having established what is simply irrelevant to the appeal itself.
Yeah, that's a really good point as well. Because actually, if you do get a statement of common ground agreed up front, then it means everybody's got less work to do in terms of preparing evidence. Because if you agree that there isn't a highways objection, then you don't need to prepare highways evidence, so on and so forth. But then the really big one, of course, is the statement of case. So let's just look at that. And I think we've already sort of said the statement of case is important because you might not get an inquiry, in which case your statement of case might be effectively your case almost in its entirety that the inspector has in front of them. So I think even if you are anticipating an inquiry, you are, if you take a light touch approach to the statement to the statement of case, you're doing that at your own risk, and potentially missing a trick there, it seems to me.
Yeah, and I'm gonna steal your point, Trevor, because you've taught it to me throughout the years. But the statement of case is really the opportunity to tell your story, and the positive story that the development is. And it's almost walking the inspector through the positive aspects of the development, because far too often we see drafts of statement of case that are straight out on the defensive, and actually they don't need to be. They need to be telling the positive story. Yes, you need to address, if you've got a reason for refusal, you need to address the council's concerns, but that can all be part of that positive storytelling process.
A very good point, which I thought I would say, you've already said it's my
Sorry.
point. Planning is a story, and actually part of the job of any applicant for planning permission, whether it's on at first instance before a local planning authority, or even more so on appeal, you've got to sell your scheme. You've got to be proud of it, and if you're not proud of it, you shouldn't be in an appeal with it.
Yeah.
And getting that across, I think, is really important, avoiding being too defensive. So for me, unsurprisingly, because it's the thing I bang on about most, if the story is your sort of structure of your story comes back to section 38.6 of the 2004 Act, and that ultimate test that the inspector, probably far more than the average planning authority, the inspector will follow the section 38.6 test, determined in accordance with the development plan, unless material considerations indicate otherwise. And so for me, I think that positive story should always start with a proper examination of section 38.6. What does the development plan say? What are the relevant policies? How does the proposal comply with those policies? Then look at the material considerations. You look at those, bring those in, and only once you've done that, once you've reached your conclusion on what you say the section 38.6 test is, then move on to look at the reasons for refusal and explain why those reasons for refusal are wrong. But all too often, you see a statement of case that goes straight into, there were 3 reasons for refusal, and this is why those 3 reasons are wrong. You're missing a trick, because you're immediately on the defensive at that point. You're immediately focusing on the negatives of the scheme as far as the local authority is concerned, rather than actually taking a step back and giving the inspector that full story, as you say, of what it is and how it fits within section 38.6. I think that's absolutely fundamental, and it's a document that you can't spend too much time on, to my mind. The more effort you put in, the better, because you're just setting, again, as an appellant, tactically, you have the benefit of going first. You're setting the framework for how that appeal is going to play out. The local authority who comes in second, invariably their statement of case is having to respond to what the appellant's done. So you're really missing a trick if you don't maximize the opportunity of making sure that the appeal is going to be fought on your terms by getting that statement of case right.
Yeah, absolutely, Trevor.
I think sort of related to that, we would always say, there is, if there is any prospect of an appeal, there is a benefit to making sure that your legal team are reviewing an application before it goes in, so that application is appeal ready. Because all too often when we get pulled in at the point of a refusal or a non-determination, first thing we start doing is saying, well, you shouldn't have done that, you shouldn't have said this, that needs amending, that needs changing. And that just creates cost and pressure on the process, but it also creates that challenge of potentially needing to amend the scheme as part of your appeal, potentially needing to put in new evidence, revised LVIA or revised transport assessment or whatever, as alongside your statement of case. And at that point, we probably ought to just look at how does all that work, Peter, in terms of what is the process for looking to make changes to a scheme on an appeal.
Yeah, so amending a scheme on appeal was sort of initially came out, was established in the Wheatcroft case, and that effectively said that an amended scheme should in principle be the same as what was applied for. Now that's obviously a matter of planning judgment, but Wheatcroft determined that the judgment should be exercised on the basis of whether the changes are so substantial that they would actually deprive those who should have been consulted on them the opportunity of such a consultation. Now, I think Wheatcroft has subsequently been refined, but that's the key takeaway from me is that there's a substantive fairness point and a procedural fairness point, and you've got to meet both of them if you're amending a scheme on appeal.
I think that's right. So the kind of the headline takeaway for me is you are in the hands of the inspector.
Yeah.
If you are relying on making changes on at appeal, then bear in mind that you are in the hands of the inspector, and ultimately, if he or she exercises their judgment to say no, there's not very many places you can go. And so as a result, and I think you mentioned one of the key points from Wheatcroft is whether people have been denied the opportunity of proper consultation. If you are going to make changes, if you are going to rely on new reports that weren't before the planning authority and weren't subject to public consultation, we would, I think, always advise, certainly I would, and I suspect you would, Peter, you make those changes up front in your statement of case, you put that evidence in with your statement of case, because at that point, you are at least giving everybody full opportunity through all the consultation, all of the publicity that will go on with the appeal. People will have the full opportunity to consider those changes, consider that additional evidence and make their representations. The closer to the end of the appeal process that you're trying to make those changes, I think the greater the difficulty of overcoming those Wheatcroft tests for me.
Yeah, I think you're then in sort of the unwelcome realms of trying to persuade the inspector to adjourn the appeal to allow a period for consultation, which is always going to be difficult, I suspect.
Yeah, absolutely. Having said that, it is possible.
Yeah.
And you can make actually sometimes some quite significant changes. And you and I have recently been involved in an appeal in Camden, where this was quite a big issue, and it was related to the Building Safety Act, which came in during the course of the appeal, and suddenly a second fire escape was needed on the building, which was quite not insignificant change to the scheme. But the inspector was persuaded, wasn't she, in that case, that it could be done in the context of Wheatcroft.
Yeah, she was, and actually, I think she dealt with it really well, because she sort of had regard to both the substantive and the procedural points, and on the substantive point, she had regard to whether there would actually be a change to the description of development in the application, or the nature and the use of the development, and ultimately concluded that there wasn't. It would still be a 15-story building and was still going to provide for student accommodation and an affordable workspace. And actually, the fact that the developer was providing actually 14% less bed spaces as a result of the need for this new fire escape didn't persuade the inspector that the scheme was substantially different to what had been applied for. And then on the procedural point, I think again she was really clever, because actually she said, well she carefully reviewed all of the consultation responses that had been received, and actually found that no one had complained about a fire safety risk. So she said, well, actually there's no one in the original application that's going to be prejudiced here. The only people that have objected of the London Fire Brigade and the HSE, and there is now a period of time that they can be consulted on with this new staircase. And what she did was set a timetable for sort of the provision of updated drawings, and consultation was allowed to happen.
So it can be done. It can be done, but you need to think quite carefully, and you need to get the time of it right. And if at all possible, don't make those changes on appeal. Have the application right to start with. And I think that, for me, is less about whether that change will be accepted or not, but it's more about coming back to the story. If you are having to change the story during the course of the application and the appeal, that just starts to undermine your credibility. If you've put the application in from the beginning, you've been positive about it, you've sold it, you've defended it, that just makes for a more credible story. And ultimately, there will be at least two stories in play in an inquiry. There'll be your story, and there'll be the local authority story. And there may well be third parties who have their own story. And part of what you're trying to do is persuade the inspector that your story is more credible. And if you've been forced into making changes throughout the process, that just undermines the credibility of your story. And so I think for that reason as well, get it right at the first point. And there's probably a related point there, just to touch on briefly, which is during the course of an application, you will quite often make changes at the request of the local authority. And you will do that sometimes, even though you don't like them, even though you think it impacts on the design, it has a negative impact on the scheme, you will do it because you're trying to negotiate. And I think you need to be quite careful if you think there's an appeal coming up, because those changes can come back to haunt you. You might have agreed it because the local authority wanted it, but actually if the inspector doesn't like it and prefers what you did originally, then you find yourself in a difficult situation on appeal. So there's a balance to be struck when you are deciding whether to accept changes at the request of the local authority, if you've got an appeal in prospect, you ought to be taking proper advice before doing that, just to make sure that you're not actually creating a rod for your own back when you do something that you regard as harmful, detrimental to the scheme, in order to try and get a negotiation, and then find that that detriment becomes a reason for refusal on appeal. That's a depressing place to be. So it's best to avoid it. Really briefly, because I'm conscious of time, and we've got a few questions coming through that I'll try and get to. But I think one of the things we haven't really talked about, we touched on the 106 earlier, Peter, but I think an appeal, one of the real benefits of an appeal, if you're there on appeal anyway, to my mind, all bets are off the table with a 106. It seems to me that we always have to concede things, whether it's whole obligations that are unjustified, as we talked about earlier, or we end up having to agree, pointless triggers, everything payable prior to commencement for no apparent reason. All of those sorts of things you can take off the table if you're willing to on an appeal. And quite often you'll see applicants trying to agree a Section 106 agreement with the local authority in an appeal. And actually, quite often we take a different approach, and we kind of quite quickly take the agreement off the table and just go down a unilateral undertaking route, in order to just say, look, you're getting these contributions prior to occupation because they're linked to occupation, or you're getting it in this way, or the indexation provision is going to look like that, or whatever it is. Because actually, almost always, the local authority's position is quite hard to defend on appeal in the 106, because usually they don't have any better reason for it than it's our standard approach.
Yeah.
Which is meaningless. An inspector is wholly uninterested in what their standard approach is. What the inspector's interested in is, does it work, and does it meet Reg 122? If so, it's fine. So I think if you're in an appeal, do have a look at that 106, because you can come to a much more commercially attractive position on the 106, cutting out a lot of the rubbish that you end up having to concede, cutting out the poor drafting that local authorities insist on because it's their standard wording. You can get rid of all of that and come up with a much better, much more effective and commercially attractive 106 package if you're willing to do so. So that's always a big benefit of the process for me.
Yeah, and I think there's a really good point there in terms of undertaking versus agreement, and appellants are often quite nervous about the prospects of an undertaking because obviously the council doesn't sign up to it, and so is therefore not technically bound by any of its terms. But there are clever ways of drafting a unilateral undertaking, such as getting deemed approvals for plans that you would otherwise need the council's approval for, such as inserting dispute resolution mechanisms that require, if the council want to dispute anything, them to sort of opt in to the dispute resolution mechanism under the 106. So there are ways around it in terms of having those unilateral obligations rather than bilateral.
And I think sometimes there's a reluctance on part of planning solicitors who are involved with negotiation of these things. There's a reluctance to back their own advice. And so they'll say, oh, well, we don't really want the local authority attacking this. Let's get it agreed in order to have an easy life. Well, if that's the advice you're getting, you need better planning solicitors, frankly, because you should be willing as a planning solicitor to say, I am right, and I'm prepared to go in that witness box. I'm prepared to defend it if I need to. And we've done that on a number of occasions. And yeah, we've not lost one yet, because we are right. And the local authority on so much of what they put in a 106 is just wrong. And there is that opportunity to do it. And probably Camden is a good example of that, again, isn't it? We talked about in the context of amending the scheme, but actually the 106 was quite a big issue there, wasn't it?
Yeah, it was. And actually that was a pretty damning result for Camden, because they always insisted on all obligations, particularly financial contributions, being satisfied prior to commencement. And they said, this is our standard wording and we don't deviate from it. But actually, when you test that, the impacts that need to be mitigated against aren't needed prior to commencement of development. And now, unfortunately for Camden, they've got an appeal decision against them that says that. So anyone now looking to do development in Camden can sort of, throw this appeal decision in their face and say, well, actually, look, this has been found not to be the case. We'll have it prior to occupation, please, as it rightly should be.
Yeah, absolutely. It's a good decision for anyone who's negotiating a 106 in Camden. You need to look at that decision.
You really do, yeah.
Then bang Camden under the head with it as to why what they're asking for is unreasonable, because the inspector was really clear, very thorough in how she dealt with the council's criticisms of our 106.
Yeah, and as part of that, we also got rid of things like bonds, where the council's requiring a bond if there's not compliance with a construction management plan. Well, actually, the council has the ability to enforce against non-compliance with the construction management plan. So we said, well, that you don't need a bond because you've got the effective enforcement, and the inspector agreed with us. You know, there is no need for a bond in those circumstances.
Yeah, it was worth spending an entire day. It cross-examined on why
it was painful.
It was painful. Without lunch, we didn't even stop for lunch. I've never been so hungry in my life. Anyway, I'm conscious of time. I think one last really brief point, and then we'll try and get some questions in. But I think the next step is preparation of evidence. And I think I would simply say it's ultimately evidence is led by the witnesses, not by the legal team. But it is so important that evidence is right. And I think the big tip for me, for anyone who is preparing to give evidence in an appeal, is the mistake that witnesses make is to feel they've got to defend everything. And the problem is there will be weaknesses in your case. Nobody has a perfect case. There will be weaknesses. If you try and defend those, then particularly in an inquiry when it comes to cross-examination, you will be attacked on that. You will have to make concessions on the stand, and suddenly your credibility starts to fall apart. So my tip for witnesses is always acknowledge your weaknesses up front. Be open with your legal team when you're drafting your proof of evidence about where those weaknesses are, and make sure they're acknowledged in the proof. Because if you've acknowledged the weaknesses in your case before you get to cross-examination, then the advocate on the other side has nowhere to go. Because when they find a weakness, you go, well, yeah, I know that's a weakness, and this is how I've taken that weakness into account, and my conclusion is still the same. So that's kind of my hot tip for witnesses: is don't feel that your job is to defend everything. Actually, your job is to give your professional, honest views. And that includes accepting those weaknesses, and quite often accepting the weakness in the case up front makes your case so much stronger than if you try and paper over the cracks and then it falls apart and your credibility in front of the inspector falls apart under cross-examination. That's not a great place to be as a witness. Shall we go on to some questions? Because we've got quite a few here. I think one that came through quite early, Peter, was around sort of PPAs, and apparently a Welsh planning authority looking to charge £300,000 for a planning performance agreement, and the applicant perhaps not unreasonably saying no thanks. The question is, if you refuse to enter into a planning performance agreement when the planning authority is offering one, would that influence the planning inspector? I think the answer is no, isn't it?
No, yeah.
You're not under an obligation to enter into one. It's something that is there if you as an applicant wish to avail yourself of the process, but I don't think you can be criticised for not, especially if they're
£300,000, yeah,
£100,000 to enter into it. That's extraordinary. I'd love to know which authority that is. Make sure I never have a client put a development in there. Another question around someone who hasn't dealt with an appeal before, but saying, is it possible to settle an appeal before the inquiry or the determination of the appeal? I think the answer is no.
Yeah.
Ultimately, once you've appealed, then the inspector or the Secretary of State, if it's recovered, has jurisdiction to determine the outcome. So it can't be settled. But having said that, what you can have is another application running with the local authority, the sort of twin track approach. And once the appeal's gone in, particularly if there's a cost risk, then that can encourage a different approach between the parties and a more consensual approach. And of course, if you get to the point of securing planning permission on that other application, then it's possible to withdraw the appeal. You need to deal with costs as part of that, but you can withdraw the appeal. So that's sort of as close to settling, I think, as you can get in a planning appeal context, isn't it?
Yeah, I think so. I suppose the other way is to get everything in the statement of common ground, so that the inspector realizes that they've really got nothing to deal with. But I would always go with your method, Trevor.
We've had a couple of people interested in our Camden appeal scheme. I'm not going to pretend I know the reference off the top of my head, but we'll circulate details. As always, we circulate case references with with the follow-up email, and we'll also make sure it's posted on the text for the YouTube version of the broadcast as well. So we'll get that to you. But unless, Peter, you've got a much better memory than me,
no.
I know here and now.
But we'll also put, because it was a separate decision for the Wheatcroft principles that we were talking about earlier, so we'll put that one in as well.
Yeah. And then a question around amendments, and one person has said that their recent experience with planning authorities is that they're sometimes not willing to look at amendments to try and resolve reasons for refusal until after the appeal has been submitted, unless you pay for a pre-app. Well, I mean, ultimately, planning authority can do what it likes, I suppose, to an extent in that. But if there were amendments that were possible to be made, and particularly if the local authority doesn't then object to those amendments when you try and make them on appeal, but they refused to make them prior to determining the application themselves, I don't think you can stop that. But it seems to me that's starting to look like unreasonable behaviour that justifies a cost application, doesn't it, Peter?
Yeah, exactly. That's what I was going to say. Yeah, it feels very unreasonable, and it feels like you could put a robust case to try and get your costs back for the appeal.
Great. Well, we are coming up to time. We've always tried to be less than an hour, and we've got 3 minutes left, so that feels like a good time to bring this to a close. Thank you for all your questions. I think we've got through all of them, but if there are any that we haven't answered, please do, as ever, feel free to reach out to either Peter or me or any other member of the DLA planning team, and we'll happily try to answer them for you. But otherwise, we'll be back. Our next episode, we will be looking at the long-awaited. It's no longer a LERB, it's now a NURA. The Levelling Up and Regeneration Act, as it now is, will be our next topic, looking at what the implications of that new legislation are for the planning system. Yet more change. That's what we all love in the planning system, is constant change. It's brilliant. But we'll be looking at the next in the next session. But in the meantime, Peter, thank you very much for joining me, and thank you to everyone who has joined the live broadcast, and goodbye.